Barker. Bonette is absent. Fox. Kauth. She's not here. Kennedy.
Here.
McPherson.
Here.
Morgan.
Here.
Pendrell is not here. Plucker.
Here.
Prestai is not here. Quinn.
Here.
Reddick.
Here.
Salgado is not here. Sotolongo.
Here.
Kratz.
Here. Okay, with that, we'll open up the meeting. First of all, I would like to mention is...
I got missed.
Oh, you are? Okay.
I'm here. Sorry.
Salgado is here.
Just want to mention that the open meetings requires that we provide a copy of the Open Meetings Act. It's on the wall over here to my right. If anybody needs to or wants to look at it, they're welcome to do so. Approval of the minutes for the previous meeting. Is there a motion to approve the minutes from the previous meeting?
Motion to approve.
Second somewhere?
Second.
We don't do a roll call, Matt, do we?
Yes.
We do a roll call? Okay.
Barker.
I'll abstain.
Bonette is absent. Fox. Kauth is absent. Kennedy.
Yes.
McPherson.
Yes.
Morgan.
Yes.
Pendrell is absent. Plucker.
Yes.
Prestai is absent. Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Abstain.
Kratz.
Yes.
Motion passes.
Next, we'll go on to consideration of charter amendments. With that, we have a number of them proposed on this agenda. Bernardo introduced most of them, and from there, Bernard, the first one's yours.
Yep, the first one is a layover from the last meeting that we had. And the language that I had in the last meeting is kind of the first one on my page because I put two options. As you'll recall, at the last meeting, there was discussion about how the vacancy was filled and the desire to have a public hearing where the applicants could be heard. I attempted in writing this based on the discussion at the that we had at this place to put something in place because there was also discussion about not only would the candidates have a chance to answer questions, but the members of the public might have a chance to answer questions. And that's kind of how I written. I know it reads a little clunky and it might be, I might still tweak the words a little bit, but I did get some feedback from Ms. Bonet on this particular provision. The one I drafted is you'll see the applicants, either the applicants for the vacant position or if there's more than three, the three finalists for the position would then answer questions from the sitting council members, and then I included and the public. Her suggestion was that the public not be part of asking the questions, but the public would be able to make comments at the public hearing. So that not necessarily directing questions to the three applicants, but that there would be a public hearing in which public could make comments as to the relative merits of the three applicants. And that seemed like a reasonable alternative. You have these two particular things, but obviously they can be amended. My hope was to try to capture what this convention was discussing at the last meeting and put something out there for discussion. So happy to answer any questions.
Thank you. Public hearing. Anybody in public wants to discuss this pro or against? If not, public hearing's closed. Comments, discussion from the committee? And if not, is there a motion on one of these?
I'll move the alternate version.
Is there a second?
Second.
Discussion? Okay, let's do a vote.
Barker.
Aye.
Bonet is absent. Fox.
Aye.
Health is absent. Kennedy. McPherson.
Yes.
Morgan.
Yes.
Pendrell is absent. Plucker.
Yes.
Christi is absent. Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion approved.
Next we'll go to B, proposed section to 6.11. With that, Ryan Reason will do the introduction.
Good evening, Ryan Weeson, Assistant City Attorney. This proposed amendment comes from the Human Resources and Legislative Subcommittee. The changes that have been proposed in this amendment deal primarily with prohibitions upon city employees' participation in certain campaigns for elected officials or positions. As a general matter, it expands the scope of this prohibition by previously the charter provision only restricted the participation in campaigns for mayor or city council. This expands that to any public office. Additionally, there is language that was inserted to prohibit 3 individuals in the classified service who are directors, the city attorney, the fire chief, and the chief of police from taking certain actions, which would include using their uniform to publicly address or endorse candidates, using their title for the same purpose, or using their position. We analyzed some of these proposals under First Amendment considerations, because anytime you restrict an individual, anytime the government restricts an individual's speech, that may have some First Amendment restrictions. With specific respect to the limitation that's being proposed upon the 3 classified directors in the classified civil service, the city attorney, the fire chief, and the police chief, the prohibition on using that individual's uniform, that's already contained in this charter provision as it exists. And now that's also a very concrete example. I can look at a photograph or a video clip and say, yes, this person is wearing a uniform, or no, this person is not wearing a uniform. Same thing with that individual's title. It's very concrete. I can prove yes or no, this person has utilized that title, or this person has not utilized that title. There is a certain level of ambiguity, I feel, in the term position. What does that mean? Is there an expansive definition of it? Is there not an expansive definition of it? I don't think that the department has been able to conclude one way or another whether or not that ambiguity would violate the First Amendment, or whether that ambiguity could not violate the First Amendment rights of those individuals. That's a consideration for the Charter Convention to debate amongst yourselves and determine whether or not it is an appropriate thing to propose. But we did want to at least make you aware of the fact that there is that ambiguity, that it is open to interpretation, whereas the other examples that are listed in this section, uniform, title, whether or not the employee is engaged in those campaign activities while they are on the clock working for the city, or whether they are on their own private free time. Those are all concrete examples that there is not as much ambiguity in, that you can look at, the facts, you can look at a picture or video and say, yes, this person is wearing a uniform, no, this person is not wearing a uniform. With that, I'm happy to answer any questions.
Let me ask a couple, first of all. The way I read this is that city employees cannot participate in a campaign for any office during working hours.
Correct.
That's your intent. And then secondly, outside working hours, they can still participate.
That is my understanding.
Right. I read it the same way. But then secondly, with respect to those with 3 positions in the classified service, they cannot participate in any campaign at any time? Am I reading it correctly?
As my understanding of it is from the Human Resources and Legislative Subcommittee, and if there are any other individuals who are on that committee who would like to chime in as to what their understanding is that in addition to all the other restrictions that are already there, that for those 3 department heads that are listed, there are some additional restrictions. Again, the first instance is the restriction of the uniform. That's not really an additional restriction because that's already there for all city employees. It adds a restriction of the use of title, the title of the city attorney of the city of Omaha, the title of police chief of the city of Omaha, the title of fire chief of the city of Omaha. Again, those are specific titles. It wouldn't necessarily prohibit, say, Mr. Kuzi, I'll use as an example, from saying, my name's Matt Kuzi, I'm an Omaha resident, and I'm an attorney, and I endorse that person. But it would prohibit Mr. Kuzi from saying, I am the city attorney of the city of Omaha, and I endorse this person. It adds, again, with the specific language that the subcommittee has proposed, also the idea of position. Position is not really defined, so what does that mean? Do you take an expansive view or an expansive definition of position, or do you take a more limited definition of position? Those are kind of open-ended questions at this point.
But it doesn't prevent those positions from going out and putting up signs, working in a campaign. You're just talking about publicly endorsing somebody. Is that correct?
That's my understanding. So long as that is occurring off-duty, not using city resources, not using city time.
Okay.
And in addition, from the HR and legislative subcommittee's position, they're not using the influence and power of their role. If, as an individual, we didn't want to limit anybody's voice, but we did want to limit their ability in uniform or on work hours, during work hours, to try to influence somebody else's vote.
Okay, kind of jumped ahead a little bit. Well, open up for public hearing. Any comments from the public? If not, we'll close the public hearing and go back to committee comments.
So,
Yes,
just
sir.
want to go on to that. So the chief of police, the chief of fire,
Yeah, fire chief, yeah.
and what's the other one? City attorney.
City attorney.
They can't endorse, period, any person.
I would not interpret this proposed language to go that far. Again, it says that while they are on duty, this would prohibit them from doing it. It would prohibit them from doing so while wearing their uniform. It would prohibit them from doing so in using their title as part of that endorsement. Again, we get to the question of what does it mean by position, and there's, again, some ambiguity in that.
Yeah.
Is the term position interpreted so broadly that it includes their just notoriety in the community? Would it go that far? I don't know. The difficulty is in you as an individual can take certain actions to limit what is being utilized when you make that endorsement. But if the Omaha World Herald or KETV or WOWT picks up that story and adds the fire chief of the city of Omaha endorses this person, and the city attorney of the city of Omaha endorses this person, that is kind of outside of your control.
Yeah, I guess as a lawyer and someone that's actually taught First Amendment and constitutional law at Creighton, I kind of go back and forth in my head about what you can and can't do. I mean, I had somebody one time in my role as a school board member saying that I can't endorse other people based upon me being a school board member, and I hold my own title. I can't speak for Millard Public Schools and says Millard Public Schools endorses it. I don't get that opportunity, but because of who I am, my knowledge and my experience, I think that's a limit on free speech. I guess that's my concern is, should you wear your uniform when you're making the endorsement of the organization you work for? No, and I think there were some issues in the governor's race with that. I know Charles Herbster ran some ads, and I think maybe Jim Pillen did too, and they kind of got slapped for that you can't do that. I think that goes without saying, but I think you think about it, and I'll just use the current person because I think that's probably where some of this is coming from. For example, Todd Schmatter. I hear he's endorsed some people. He's the police chief. So if he says that Joe Smith will be the best dog catcher ever because he'll be tough on crime, or so to speak, then I think he has the ability to say that because that's his knowledge and experience. And that would apply to any chief down the road or chiefs in the past. I get really worried about trying to limit people because why are they making that recommendation? Because they're knowledgeable about something and do something. The other thing I worry about is because I know some people think, well, this is something going on now. Is it because you don't like the person that person endorsed or could be endorsing? or is it something long-term in a project? And I don't know what everybody's, the reasons why they put this together or had these thoughts. I always think people have good intentions, but I look at the implication down the road, because I tend to think voters are pretty sophisticated and can see through it and see why they have that. But I mean, if you have a person that's doing good at a job and says, you know, I know something about law enforcement in Omaha, and I think Joe Smith would be the best person ever, or Mary Smith to do it, or whomever it is, and say that they're going to be best for it, I don't think we can limit that, nor should we. I have an issue with that. And the title is what the title is given to them. I don't want people doing it during work. I think we all agree upon that, wearing the uniform, but I would be against that provision of it.
And I might add that some of the language in here says, or take any active position to support or oppose any candidate. So those three individuals, even not publicly and even, you know, out of uniform, sounds like they can't go put up signs or do other things that they do in a campaign. If I'm reading
Can
it
I mention
correctly.
something? I think, Armando here, I think it has to do with being paid on public tax dollars, on people's tax dollars, and going out and, you know, I do have an issue with that. I guess not so much, you know, taking away their free speech, and they can do that, but while they're working, that I personally have an issue with that, with them using, you know, their time for campaigning on somebody else's, you know, deal. I don't really know of anybody else right now doing it. I'm not saying it because I don't like somebody else. I just don't think that's right to be using, you know, the public's tax dollars to be campaigning for somebody else.
I do want to make one thing clear, just legally. There is already state law and city code that prohibits employees from campaigning for anybody during their paid time. And also there is state law that prohibits people from doing it in uniform, which is obviously some of the things that we saw in the governor's race. And so those prohibitions occurred. The question, I think, is this is intended to broaden that to now in your off-duty time.
Yes.
Are you limited from doing that because you hold one of these three classified positions? So I mean, there are some other restrictions that already apply, and I think the changes to the first part by expanding the positions that it applies to, not just mayor and council, but to any elected position, makes it even more explicit that you can't do it, that any, frankly, any city employee, not just the three classified people, but you know, people like me who are just a regular employee.
Brian Wiesen, Assistant City Attorney, and I would also add that the existing prohibition in the section in the charter that prohibits employees from engaging in political activities and campaigns while on the clock, on duty, does already apply to these three classified service positions. It already applies to the city attorney, it already applies to the police chief, it already applies to the fire chief.
I'll give you a good example. My good friend Jim Begley, Jim's on the MUD board, he's a city employee. Jim would never take a call or do something while he's on city time. He does that respectfully outside of his time. I would assume that the chief, firefighters, police officers, people working on the streets are going to do the same thing. Like I said, I'm aware of these other statutes, and I think they protect from that. I just get really worried about limiting 3 people and expanding it to other races. And I have heard from some people from the political debate of it, some people aren't happy because there could be an endorsement that's been made in the sheriff's race, and I think maybe that's part of this. I don't know. And some people in the community, but the problem is I don't look at it who's doing it now or what it is. I'm more looking at what the impact is, because the guy that may be in there now, the next one could have a totally different opinion of who they would vote for or support. So
I'm just going to jump in. I appreciate the clarification. Again, I agree with Armando that when you're on city time, shouldn't do it. Shouldn't do it in your uniform. I do believe that you can support people, and given your title, doctor or chief resident of pediatrics, there's some validity as to why you're doing that. Yeah, I like how it was originally worded.
I would echo that. I don't think you can take someone's title away from them. I think it's just part of, their CV, their resume. And I also, like Mr. Kratz said, have an issue with the take any active position or support. I don't know what that means, and I think it further limits. But I do agree on work time in your uniform. It should be prohibited as it is currently.
I want to raise one issue just because I think in fairness, this came out of the HR committee. It was written by Mr. Pendrell. I did get an email from Mr. Pendrell about 5 minutes before the meeting started that he wasn't going to be able to be here. I know it's an issue that he was concerned about. I know it's an issue that Ms. Bonet was concerned about, of course. Those are 2 of the 3 members of the HR committee aren't here. I just point that out just because I appreciate they might have, if they were here, might be able to offer a different perspective or have something else. I just want to point that out in fairness to the 2 of them as well. I mean, obviously do as you please. I just wanted to point that out.
Duly noted, and as the least vocal on that HR and Legislative Committee, I'll just say I would recommend that we lay this one over. And the reason I would ask that to be the case, we are on item number 2, and we have many to go. And the people who really were passionate about it, even though I have some thoughts, I will tell you that they are very able and committed to communicating their position. So my recommendation would be that we lay it over, and I would like to make that formal if we're done with other people's comments.
Is there a second?
Second.
Any other discussion? Let's do a roll call.
Barker.
Yes.
Bonet is absent. Fox.
Yes.
Kauth is absent. Kennedy.
Yes.
McPherson.
Yes.
Morgan.
Yes.
Pendrell is absent. Plucker.
Yes.
Prestai.
Yes.
Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion approved.
It's laid over till the next meeting. The next item is number C. It's a proposed change to section 2.07, paren A, close paren. With that, Mr. Ingenbosch.
All right. Bernard Ingenbosch, Deputy City Attorney. Now you're going to get sick of me for a while. The next 3 amendments are kind of 3 different things that are sort of related to each other, but they do have some differences. So the first one that's before you, 2.07, applies only to 2.07. And this was, the mayor made a recommendation to the Charter Convention that the provision in 2.07A regarding her absence to the city before she needs to notify the city council president be 10 days. There was some discussion in the administration and mayor's subcommittee. I know they've talked about this a fair amount. This language comes out of their couple meetings and a meeting that I had with them this past week. The intent of it is that if the mayor is absent from the city for a period of more than 5 business days, or requests the president to act as mayor. There could be situations where the mayor may be out of town for a couple of days and may want that situation where she's not going to be able, he or she, and I'm saying she because obviously that's the current mayor, but this is obviously not written for an individual mayor, it's written for all, or if they were disabled as provided in section 3.06, this would allow the mayor to remain and serve as the mayor for that period of time. If it was 5 business days or less, unless they requested that it go to the council. I think this is intended to recognize changes in technology, changes in accessibility, changes in being able to do things that have occurred as a result of technology and quite frankly are probably going to continue to accrue as technology changes. So that's section 2.07, the first one before you.
Okay, we'll open the public hearing. Any comments from the public? Public hearing's closed. Comments from the committee?
Prestai, is it possible to have Bernard
I know that there are 3 separate agenda items, so it would be possible to have Bernard read off all 3 of these, since it seems
I was just
likely that
gonna,
we should only do one of these.
I was gonna suggest that too.
Okay, that's fine.
Go
I'll
ahead.
address the next one, which is another amendment to 2.07. The first part of that amendment is exactly the same as what we have here, which is making the change to 2.07A for the period of 5 business days. The second part, again, was at a request of the mayor, and we had a relatively clunky, nice legal word, but clunky process for declaring the mayor as disabled that required calling an outside committee and doing some of the other things. The suggestion was that we should mirror the 25th Amendment of the United States Constitution, which provides a process for declaring, in that particular case, obviously the president, but in this particular case, we're talking about the mayor. The mayor could transmit that they're unable to discharge the duties, and therefore you would end up having the duties are then performed by the council president as acting mayor, or in a situation where the majority of the mayor's cabinet, and the section to 3.8 references the section of the charter that details and lists the members of the cabinet, where the members of the cabinet felt that the mayor was unable to perform their duties, again, would provide that position. And then there is, if the mayor wants to challenge it, again, it allows the council to decide on a 2/3 majority as to whether or not the mayor is able to discharge their duties. So this is very much mirrors the 25th Amendment of the United States Constitution as far as a process. The hope it would be less clunky in those situations where a mayor would be unable to perform or discharge their duties as a result of some condition. So that's kind of that's part number 2. Number 3 is a little bit is a totally kind of new approach, and so the purpose of this section, and again it was proposed by the committee, tries to follow up on some of the discussion that we had last meeting about a deputy mayor, not really creating a deputy mayor, but basically creating the ability to have somebody who would kind of act in that particular position. So what occurs here is that the acting mayor, for absences of 15 days or less, would not be the president of the city council, but rather would be a person selected by the mayor from a list of the city council chief of staff, any person that's in the cabinet, or the city council president. Of course, anybody that was appointed would have to meet the qualifying conditions in the city charter, i.e. they have to be a resident of the city of Omaha. And then an absence in situation where the mayor was unable to perform the duties of their position for more than 15 days, or they're deceased, or they're and meet the standard of being disabled, then we would go back to the provision where the president of the city council would act as the acting mayor. So the concept is, rather than create a deputy mayor, we'll create an acting mayor for short-term absences that could be somebody that's appointed from a select list, to basically act as that person. Obviously, that person, if it's the chief of staff or a member of the cabinet, would be somebody that isn't elected. I mean, we all understand that. And that list can obviously change, but that was, I think, an idea to kind of pursue this idea that if we could have a deputy mayor that would be someone that was selected by the council without creating a new position. This creates a process where those short-term absences would be somebody who could be somebody that answers to the mayor. So those are the 3 various proposals.
Okay, with that, let's take them all together. I have a public hearing on the 3 proposals. Anybody want to testify for or against? If not, we'll close the public hearing and move to comments from the committee.
I can start since I'm on that subcommittee, and I can kind of tell you with maybe their help what we were thinking. I think we definitely all agreed after many discussions that there has to be some recognition that this is a more modern and technologically advanced world that we're living in than maybe 10 years ago when they considered this in the charter, and certainly will only move in that direction in the next 10 years. So we felt strongly that there should be a number of days that any mayor can leave town while still being accessible, still being able to perform his or her duties. So that's how we came up with the 5 business days. Some were comfortable with longer, some shorter, but that was a good compromise that we ended up with. Also, I think there was general consensus that how the charter deals with an incapacity issue of the mayor is archaic and really unworkable. So this, the second, I think, option was mirroring the 25th Amendment seemed to make sense to us. It works, obviously, at the federal level and should work here. The third concept, I'm going to turn it over to Mr. Reddick if he wants to speak up, but he had really thoughtful and interesting ideas that I think were definitely, we considered them a lot and are definitely worth consideration by the whole group. But I'll let him articulate those more eloquently than I can.
Thank you. I know everybody has if they've had an opportunity to read the acting mayor section 3.04.5, basically we've grown as a city, and if we look at one of the provisions in the charter that basically states we have an opportunity the mayor's position moves to a elected official, the city council president. If the city council president is not from my district, not from my area, I did not have an opportunity to vote on that person. And so whether they hold interest still for their district or their particular section at the time versus acting as the mayor, having an acting mayor would allow that person to, again, be mobile. A mobile office could be set up if necessary, if they are reachable via phone, text, email, carrier pigeon if necessary. And they could still act as the mayor doing those responsibilities. Other responsibilities where the mayor would either be vetoing something or have to make a decision that maybe doesn't go to the acting mayor could be laid over, just like we're laying over amendments, until the mayor is able to return and resume those particular responsibilities. I know it isn't budgeted right now for a deputy mayor. That maybe could be reviewed again when it's budget time, but an acting mayor allows the person that everyone in the city had at least an opportunity to vote for to make a decision as to who is going to keep the will of the people without any other interest or any other agenda.
The way I read this, Bernard, maybe you can answer 3.04.5 as a 15-day period. The other proposals have a 5-day period. So we'd have to select one as opposed to the other. Is that correct?
Well, and obviously you could amend any one of these to incorporate language from the other, because when I did the third amendment where I added 3.04.05, you're right, it's a 15-day provision, and it uses the word unable to perform the duties, which would contemplate that if the mayor could perform the duties, the mayor would continue to do it. But I didn't change, like I kept the disability language that currently exists. I didn't include the 25th Amendment language, so you could presumably mix and match if that's what you wanted. I think the idea was just to get these concepts in front of you. But yeah, I mean, the idea is that for a period of up to 15 days, if the mayor's not there, there will be somebody who is the mayor, and for the reasons that Mr. Reddick expressed, does it make, did it make sense to force that on the city council president, or did it make more sense to make it a member of the mayor's staff or the cabinet, people who are part of the executive branch and are already working with the mayor to move forward whatever his or her agenda is?
But also would be an unelected person.
It could be, unless the mayor were to appoint the city council president. I left that in as an option, or to select.
I'm just trying to figure out how to work with the cabinet deciding if the mayor is disabled. If you get some professional input, or does the cabinet gang up on the mayor if they don't like the mayor?
Well,
I don't know how it's going to work.
And I could make the same argument, I think, in the presidential context as well. There was some discussion about the fact that, obviously the cabinet, as you know better than probably anybody in here, the cabinet is made up of 3 classified people who obviously have civil service protection for their position, and 8 non-civil service protected positions who serve at the will of whoever the mayor is. There was some discussion about whether, when we look at 2.07B and we try to incorporate the concept of the 25th Amendment, that we would, maybe as opposed to the cabinet as a whole, where 8 of the 11 are employee at will of the mayor, that you have the classified people being the one who have that responsibility. Obviously, 3 is a very small group to make that, and that was, I think, one of the reasons that we went. The suggestion was to go forward in this way. But you're right. Ultimately, I suppose that if people had a bias, the majority of the cabinet had a bias, they would presumably have the ability to recommend it. Now, the mayor does have the ability to respond, and ultimately the council is the entity that would make the decision as to whether or not the mayor is.
But the majority of people on the cabinet are appointed by her, can be dismissed by her.
Absolutely.
So if she doesn't like their recommendations, she can dismiss them and appoint new people?
No, and once the recommendation was made, I suppose she could then challenge it. And again, ultimately, the council would make the decision then. But you're right, any subsequent time, they would have that particular potential. So,
interesting.
Bernard?
Other comments?
From reading it, is it true that the cabinet for that proposed amendment couldn't just decide to vote that on the mayor? They couldn't just say it's Tuesday morning and we think it's time to move this mayor aside. They could only make that vote if the mayor discharged his or her duties. That's when they would have that 3-day window, correct?
So if the majority of the cabinet provides a written declaration that the mayor is unable to perform their duties, then the council president immediately assumes those duties. The mayor then has a window where she can say, she provides a written declaration that he or she can perform their duties, and then when that's transmitted to the mayor, then they will resume the duties, absent, of course, as you read it again, another transmittal from the council within 3 days. And if that occurs, then the city council has to decide within 48 hours. And again, the language is an attempt to convert what the 25th article of the Constitution and put it into charter language, and that's net effective how it would work.
I'm really comfortable with entrusting that responsibility to the cabinet, precisely because they're appointed by the mayor. They're not going to gang up on the mayor unless the mayor is catastrophically disabled,
right.
I think.
And not to interrupt, but I was just going to say, aren't those the people who are working with the mayor the closest on a day-to-day basis, in a better position to ascertain whether there is that kind of issue, as opposed to this the city council calling 3 random doctors and the mayor having to submit to those exams. I mean, that just is, but yeah, I would agree precisely because those are the closest people to the mayor, they would have the best ability to judge whether there was an issue.
Bernard, did you have a chance to look at how Lincoln does it? Or does anybody know how Lincoln does it?
I did not look at how Lincoln does it, so I apologize.
I had a chance to not necessarily look at Lincoln, but cities close to our size and close to proximity. Most of them have already budgeted or have either an acting or deputy mayor. And so as we have jumped from 41st to 39th, we are in not necessarily a new stratosphere, but a new era in regards to how we're going to operate as a city. And I think these outline that we are moving in a way where business will be conducted irregardless of whether the mayor is in town, out of town. If disabled, then there's a way that that happens, and we're trusting both the mayor's decisions as well as those appointees, those 3 people, and the city council. And my earlier comment regarding not having an opportunity to vote does not necessarily mean that there's contention about who that person is going to be. If we look beyond where we are now, I'm not referring to the mayor as he or she in this particular instance, because we're talking about a mayor that's not in office right now. Probably more importantly from my perspective on this particular point is if we're going to continue to attract as a city the brightest talent and the most available people, we have to, my opinion is we need to adapt to allowing that to happen, that work to be done wherever they're at. Whether that's in Omaha and its ever-growing borders, or on a plane, if necessary, on a train, wherever that's at, because we have sister cities around the world. We have other cities that we're learning from, and the mayor as well as other cabinet members go along there, and the work still gets done. So I think that's the biggest part of this, is we are allowing more flexibility for whoever is mayor, either now or in the future, to be able to continue to work. And if the time comes where they cannot, there's a clear line of succession now that's been voted on, or that list has been given by the city council, because that list is coming from them. So they play a part in it as well.
I was just going to say is, Mr. Reddick, I just think your analysis is spot on, and thank you for spending the time. As someone that goes through a lot of looking at structure, municipal government, and political science, I just think your ideas are, I think, spot on in a lot of cases. There are a lot of cities that do have kind of a deputy mayor or give the power to somebody else. I think it's something we should look at a little bit further, because here's some of the issues. When we first had the city charter come to fruition, when we changed from the commission form of government here, that's fine. We didn't have cell service, we didn't have the internet, we didn't have Skype, Zoom, all the things that have come out. And going to the 3 parts of it is this. One, I think there's the general inherent powers of the mayor, the separation of powers, which you kind of bring up in your argument, that I think we need to respect. I think having the mayor be able to be away from town and discharge her powers is very important, no matter who the mayor is. I think that we have the capability to do that. The second part I talked to Ms. Plucker about today is, if the mayor's not able to be gotten a hold of, you could delegate emergency powers to someone, whether it's the deputy mayor, your thing, chief of staff, or the city council president, that could only have emergency powers that could be quickly taken away when the mayor was there. So if the chief of police, the public works, someone from safety needed something, that the mayor needed to sign something, and he or she was unavailable, then the council president or the other person you talked about could deal only on that. So what couldn't they do while the mayor's absent or be gotten a hold of? Can't sign legislation. I don't think you should be able to do that. Things in the normal course of business, but for emergency powers, if we could spend some time focusing on that, if there was an emergency, a massive tornado comes through, you couldn't get a hold of the mayor at that time, then who makes that decision for emergency powers only. And I think that would be a good distinction. The other part of it is the cabinet having that decision, I think on the mayor's incompetency is very good. I like those provisions. And then as far as creating a new position, well, all intents and purposes, I've seen several different mayor's administrations, and usually the mayors are pretty good about who they pick for chief of staff. I mean, you had Paul Landau under Fahey. You had, well, he's a city councilman now. Brinker Harding was one of Hal Dobbs' ones. Usually have had good people that have held those positions over the years. And they're almost treated as that second in command. And, you know, we have Chief Warren here. We had Marty Bielik. I just think if we flesh this out a little bit more, and I'm not, well, I guess I'm going to say maybe we lay this over and think about it between now and the next meeting, is I would like to see those come together and see what the other advice is from the other members of this body here. Is I would like to tie all three of these up together, because I really think keeping it within the mayor's office for that period of time would be a good move, and have that defined. And then two, I think having the emergency powers and the time that the mayor's out of the city be separated. I just think that that takes care of some concerns on both ends of the spectrum. That's all I got.
McPherson.
I do have just one issue with respect to appointing a member of the staff, again, with all due respect to the chief. It seems like if you're going to have somebody else act as a mayor, it ought to be an elected official, as opposed to somebody who's just, you know, on the staff of the mayor. I think you get more legitimacy that way. The public might approve or agree with what an elected official does, as opposed to somebody on the staff.
Yeah, I'm not hung up one way or another, but here's, so the rationale on the other side would be this is, one, he's talking about a separation of powers argument, saying that within that body, because the president approves their cabinet, they essentially go up, however, they're ratified by the Senate, so that's where the legitimacy's at. I think for council president, if you keep the council president, then that second part of it with the council president is that they're elected by being council president by elected members of the seven. Mm-hmm. So that's where they gain their legitimacy. I don't have a problem one way or another, but after hearing how Mr. Reddick put it there, I thought that makes a lot of sense. And if there are problems, and we haven't had any problems, except going back to the Lormont Low thing with Hal Dobb 20 plus years ago, we haven't had these big fights. But I think we do have to update it, and whether it's the chief of staff or a deputy mayor or the council president, I do want to see a differentiation between emergency powers. If you can't get a hold of the mayor, who does that? I think we got to delineate that. And then the day-to-day stuff, that can be handled. The mayor can be out of town for 10 days. I don't have a problem with that. I mean, when you go to Shizuoka, if you go to Japan, you're the mayor of Omaha. You're not the mayor of Omaha because Pete Festerson's here back home. Or if you go to the council of mayors, you're still the mayor. And I think we can adapt out of that.
And Mr. Kennedy, you're comfortable, you're saying if there is an event where the mayor is out of town and not, and we kind of talked about easily accessible, readily accessible, some term like that, and I don't know that you want to put a time frame on it, but that's when you're talking about there's emergency powers that could be conferred on whoever we determine, but
Yeah.
not other.
Correct. So here would be the issue, because I kind of see this, and maybe Chief would know this better than I think our police chief and fire chief, let's just say Von Maur shooting, police chief goes out there. I don't think the mayor is out there directing what's going to happen. Mm-hmm. I think of more of the tornado in Omaha and directing resources, that type of thing. If for some reason the mayor is trapped, her house collapses, or she's out of town or something like that, and nobody can get a hold of her, then, and something emergency has to be made because there's indecision in the cabinet and or how to respond, then I think the next one up is the council president, or as someone, Mr. Reddick, stated, I think that's what you have, but it's only for that emergency. It wouldn't be for anything else. You're not going to sign a contract, a redevelopment agreement, or anything like that, but specific to the emergency. And then when the mayor is back, he or she can make the change to rescind that decision or do that. I think what we're taking care of is, I think everyone's worried about the tornado or the blizzard scenario, right?
Yeah.
And Mr. Kennedy, we did talk at length about that in our subdivision meetings. You know, what happens in the emergency? What happens in the Von Mauer shooting? What happens in the fire, you know, the historic fire that just occurred? And it was clear through those conversations and other conversations subcommittee members have had with those people that are would be in charge of those disasters, that it is not the mayor's job to go out on scene, you know, to show up at Von Mauer while there's, you know, an active investigation going on. So that's where we got more comfortable that, you know, yeah, as long as the mayor's able to direct personnel and, you know, provisions where they need to be, that having the face at the emergency, which is kind of what we got caught up on, I think, the first time we discussed this in a larger, with the larger group. So it was good having that perspective that, you know, the mayor's not going to run to the site of the 5-alarm fire and get a hose and start putting out the fire.
Yeah, I think the concern is if you can't get a hold of the mayor.
Correct.
Or where the mayor's at.
Yep, correct.
I think that's the issue. So if you're thinking about if a decision has to be made at the mayoral level and you can't get a hold of the mayor for any reason, then what happens? And then the solution to that could be, one idea, is the council president or somebody else steps in and can make an emergency decision. But usually those things are kind of set in place. I mean, if there's a riot, the police handles that, if there's a thing. But there may be something, and I'll give you I hate to use this example, but what happens if something major here, there's civil unrest? Can the police chief call the National Guard, ask for the National Guard to come in? I don't know. I mean, that's why I think you have some emergency power given to somebody if the mayor is not available for a phone call, Skype, whatever it is.
McPherson, in support of moving this forward, the dialogue has been fantastic. And what Mr. Reddick proposed was very clear. Can we get some understanding on what the contention points are so that we can ask the committee as we lay this over, because we're not going to resolve it now? Is it possible for us to understand what points do we agree with, what points do we not agree with, and then we send the committee back with whoever else wants to be part of that discussion so that we can more clearly identify what that text or what that submission would be?
That's a great idea. I can take a stab and maybe we can have discussion. If it sounds like we are agreeing on there is a period of time, whether it's 5 business days, 10 days, as the mayor suggested, that the mayor can be out of town without losing those powers, without informing the president of the city council. And then Mr. Kennedy is suggesting that, and I think I'm seeing nodding, that during that period when a mayor is out of town, the mayor should be readily accessible in the event of an emergency. And if not, there is perhaps a transfer of emergency powers only until the mayor is available. That seems to be, everyone's kind of nodding. Secondly, the incapacity issue, treating that more like the 25th Amendment of the Constitution and not how it is currently in charter, seems to be in agreement. The third issue is Mr. Reddick's explanation of should the mayor, upon whatever desire leaving town, be able to designate to his or her chief of staff or cabinet person or city council president to perform duties while he or she is out of town. I think that's the third one. It needs more exploration, but feel free to disagree.
So you're suggesting then, without that list, do we send this back to the committee to further define maybe what an emergency is, whatever else needs to be put into it?
The committee and whoever else is so committed to, because what happens is the committee goes and considers it, they make updates and edits, they bring it back, and we go over it again, right? For those who have passion, and I appreciate the points that Mr. Kennedy made. I thought they were very clear and should be included, but we're not going to get it done here. So
yeah, I feel like, I mean, I don't want to speak for the rest of the committee, but I think the committee has has discussed this. They feel comfortable with, presenting it to you all today. I think we can take a stab of working with Bernard on the readily accessible and emergency powers. That seems more of just a list. But the third issue, I think maybe we just need to marinate on for a week or whenever our next meeting is, and then have the members that aren't here today and just have more robust discussion, or unless people want to get together but I think the committee has come to where they're comfortable presenting that.
I believe the committee is well able. I'm just saying very clearly that the next meeting is July 11th. And so in my mind, they have until July 11th, whoever's on that discussion, to bring it back. But remember, when you bring it back, for any empty chair that you find in here, we're going to have more voices, right? So we're going to have another robust discussion, and I'm sure that we're all ready for it, but our time just doesn't allow for it.
And that's fine. And I kind of contemplate that we'll come back with two options for you the next time. One will be an option that has the whatever 5 or whatever days, includes the 25th constitutional stuff. And then the second will be mirrored kind of on the last thing that we're talking about as a 3.0 or a 5, but we'll incorporate that 25th constitutional amendment. So you have two options. We're obviously going to have to address this emergency situation in both, because that's obviously kind of the variable that we didn't address in here. So that's what I would envision. But obviously, if the committee wants to do more, I think we want to try to make it simple for you and try to narrow it to a couple of options, and then you can decide what's the will of the convention.
McPherson, I move that we as a committee lay this one over, directing the subcommittee to retool and provide two versions as they come back to us, the larger charter convention body.
Second.
Go ahead.
Reddick, second.
Okay, let's do a roll call.
Barker.
Yes.
Bonet is absent. Fox.
Aye.
Kauth is absent. Kennedy. McPherson.
Yes.
Morgan.
Yes.
Pendrell is absent. Plucker.
Yes.
Christi.
Yes.
Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion approved.
Okay, next we'll do number F, which is amendment to the charter section 2.08.
Again, this is and I appreciate the discussion, frankly, because I thought the last three were going to be probably in many ways the most important ones we're going to have to discuss. So I knew they would take a little bit of time. The next ones should hopefully be a little quicker. So again, the revision to 2.08 was a request made at the request of the mayor's office, basically to provide a line of succession in the event that the mayor was unavailable, president of the city council was unavailable, and the vice president of the city council was either unavailable or disabled. And there have been circumstances over the past couple of years where all three of those folks that are laid out in the charter as potential people who'd be acting mayor have been out of the city. So the thought process is we need to explore a further line of succession. You'll see Bernard created an arbitrary one, and I'm subject to any one of you telling me to change it or do whatever else. The line of succession that I kind of contemplated would go from longest serving council member to the shortest serving council member, also appreciating because people serve terms. And then I tried to come up with a rule. How do I differentiate between two people who've been on the council for 8 years? I put a tiebreaker in. Any tie and length of service shall be decided in favor of the lower numbered city council district. I appreciate that's just like flipping a coin, but I wanted to put something in there that would make it clear. So obviously, if the will of the convention is to do something else, or somebody has an idea of a better way to break ties, I'm all for hearing it. I just wanted to give you something that I thought worthy of discussion and consistent with the concern that the mayor has expressed as far as there not being one of those three people in town, which, as I said, has happened.
The public hearing. Anybody from the public want to speak to this one way or the other? Public hearing is closed. Comments from the committee?
beautifully constructed, Mr. Bernard.
My only comment would be it's well written. I just, the last part, I don't think the tiebreaker should be based upon the number of your district. And I know you just put that in there for thought. I think you should I think the council, since they select a president and vice president, they, at their first meeting, can also select the order. I think that's within their body. Councils change every election or upon new people coming on board and people leaving. I think that the council should put it on themselves to figure out what that is and pick 1 through 7 or something like that. I think it's kind of arbitrary because let's see, who's the number 1? And I never base it upon that, but it's Pete Festerson right now. So whoever holds Pete Festerson's seat, which I think covers Benson, Dundee, and that, nothing wrong with Benson and Dundee, but they have the first pick over North Omaha, South Omaha, Millard, or whatever. I think there needs to be something else, but everything else looks fine, and that's all I have to say.
So, Mr. Kennedy, would you be suggesting that the city council would decide the ties, or are you saying should pick the entire order 1 through 7?
I think there's a practical difficulty with having the city council do the ties at the time, because obviously we'd have to wait till the next meeting. So I think what he's suggesting is maybe at the time that they elect officers, they would elect an order. Now, I've watched the election of officers for the city council take hours and hours and hours. I can hardly imagine what it would take to put 7 in an order. But again, and maybe what it is just all they would do is give priority between those people who have the longer tenures, i.e.,
You can do longer tenures, and then maybe if there's a tie, and I'm just throwing this out there because I don't know everybody's percentages, but say whoever had the biggest win margin by percentage, is something like that, something that you can't tie to who holds the seat, and we don't care because it's not going to happen next year. The council will be different. I mean,
that's, you could do it the person who received the highest percentage of votes or something. I mean, that.
I would do it by percentage of vote, and here's what you want to do. We do have a disparity over a period of time of certain wards voting, and that would probably put Ward 2 probably as always at the end, because they usually don't have the highest numbers of people voting. I wouldn't want to have any ward put at a disadvantage or district put at a disadvantage, but the margins could be different, and I think that's probably a better accurate measure than just have total votes, because I
wasn't going to say total votes. I was just saying
no,
the
but I
highest
was just saying
percentage.
for people to think about why you would want to have percentages, that would be better than number of votes. So
McPherson, it sounds like everything looks good, except we need to come up with the mechanism. So if we can take a minute to just go ahead and come up with the recommendation so that every time the city council meets that it's not constantly changing the mechanism by which they're able to break a tie. Everything already looks good based on what was written. What other suggestions do we have?
Barker, I think we should flip a coin. We're imagining an emergent situation where this has to be done quickly. I think you should flip a coin.
The coin is an age-old tradition. So.
Lots are in the Bible.
Shouldn't it just be set at the new legislative term, or once all city councils are seated, or in the case as we recently had where you had a new appointee, that then the line of succession would be updated at that time? Wouldn't that be the cleanest way, so that no one has to flip a coin or look up any of these things, and state of emergency would just be well known internally?
Yeah, I think there's a practical problem with trying to get them to vote. I mean, that's and so I do appreciate the game of chance of coin flipping, which and that's fine. I mean, whatever mechanism the convention thinks, it's fairly easy to write. I do think it would be difficult to have them rank people. One, the hope is this doesn't happen very often, but two, just the minutia of the decision making or whatever else. I'd hate to have a 2-hour contested vote over who gets to be third, fourth, or fifth in the line of succession for something that the likelihood would never be
If you want to leave it this, because I'm familiar with some different election laws, so if you want to break ties, a couple different ways you can do it. You can use the percentage method that I set for you, that everyone would know in advance. Or the one that's out there is if you have 3 or 4 people, it's deck of cards as opposed to a coin flip. And there are elections decided in this country by, if there's 4 people or 3 people, it's whoever has the ace, and it's in order. So if we want to narrow it down, I'm just throwing that out there. If you guys want to leave it to percentage of vote, that's one way. Or if you want to flip a coin, I think probably if you have 3 or 4 people that were elected at the same time, you have 52 cards. Someone's going to have a high card, someone's going to have a low card.
Then McPherson, we're going to have to argue about the suit. Look, y'all, we are we're spiraling. Okay, everything looked good except for what would break a tie, right? So
Does anybody have a problem? I mean,
Yeah, that's
how
good.
about percentage of vote?
Yeah. Does somebody have a motion? Let's get this.
Okay.
hey, I was going to make one.
Yeah,
I ain't want
there
to
you
cut
go.
people off.
Go for it.
Just last question, and it's a very simple question, so I can only have to do this once. Do you all care on percentage vote or coin flip? I mean, do you care? Okay. Okay. McPherson, I move that we move forward with item 4F, proposed amendment to Charter Section 2.08, with a modification to the wording where we include by percentage of vote, or however it was worded. Please, let's not argue about that. Period.
And that's with respect to the last sentence.
Yes, sir. Last sentence.
And I'm happy to read. I've tried to write out a last sentence, so I'll read it.
Go ahead, Bernard.
Any tie and length of service shall be decided, of course I can't read my own handwriting, in the form of in favor of the council person who received the highest percentage of votes in their district in the most recent election.
Is there a second?
Second.
Second.
Okay, any further discussion? Let's vote. This will be to amend this proposal. Then we'll vote again. Yes.
Barker.
Yes.
Bonet is absent. Fox.
Aye.
Kauth is absent. Kennedy.
Yes.
McPherson.
Yes.
Morgan.
Yes.
Pendrell is absent. Plucker.
Yes.
Prestai.
Yes.
Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion approved.
Then we'll have a vote as to the proposal as amended.
Just a motion to approve as amended.
Reddick here motioning to approve as amended.
Fox, second.
Barker.
Aye.
Bonet is absent. Fox.
Aye.
Kauth is absent. Kennedy. McPherson.
Yes.
Morgan.
Yes.
Pendrell is absent. Plucker. Prestai.
Yes.
Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion approved.
Okay, next we'll go to item G, which is proposed amendment to section 5.03.
And you'll recall, this is an amendment that was proposed by the Finance Department, and you'll recall we discussed it at our very, very first meeting. And this was the provision that allowed for the reserve fund instead of not to exceed 8% of general appropriations. And I got to make it clearer in my underlined copy because it doesn't look quite as clear as it's intended. Increase that balance from 8% to 12%.
And that language is found in the last paragraph.
It's in
this
paragraph
proposal.
10, right at the very end of paragraph 10 of 5.03.
Public hearing? Any public testimony? Seeing none, public hearing's closed. Discussion by the committee? If not, is there a motion?
Motion to approve Charter Section 5.0303.
Second by anybody?
Morgan, second.
Let's do a roll call vote.
Barker.
Yes.
Bonet is absent. Fox.
Aye.
Kauth is absent. Kennedy.
Aye.
McPherson.
Yes.
Morgan.
Yes.
Pendrell is absent. Plucker. Yes. Prestai.
Yes.
Quinn.
Yes.
Reddick.
Aye.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion approved.
Next one's section 5.06. Mr. Indenbosch.
This was one that was proposed by the Finance Committee, and I know there were a couple different people who suggested it, some internal, some external. There are some situations where there may be a budget amendment in front of the council and there's a public hearing on that, but on occasion, that budget amendment may be amended by the council, and in those instances, there may not be a public hearing. And the concern was that if there was any amendment which increased, decreased, or in any way changed the budget, there should always be a public hearing to discuss that. So this, in our budgetary process, we will have budget amendments brought forward by the council. There are public hearings on those, but what does occur in some occasions is there may be some bartering or the discussion leads to people saying, maybe here's a middle ground we can reach, and it ends up being, after the public hearing is closed, an amendment that occurs, and in that instance, there may not in fact be a public hearing. And the desire is to ensure that if there was going to be any change, so this is an attempt to make that clear. It would merely require the city council to open up for a public hearing if there were an amendment after the previous public hearing was already closed.
Okay. Speaking of public hearings, open it up for a public hearing. Any comments? Seeing none, the public hearing is closed. Comments from the committee? A motion?
Motion to approve the amendment to section 5.06 is written.
Second.
Let's do a roll call vote.
Barker.
Aye.
Bonet is absent. Fox.
Aye.
Ralph is absent. Kennedy. McPherson.
Yes.
Morgan.
Yes.
Hendrill is absent. Plucker.
Yes.
Prestai.
Yes.
Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion approved.
Next one is section 5.16. Mr. Indenbosch.
All right. This is one, as you'll recall, it kind of starts with the original request by the Finance Department, but ultimately the Finance Committee made some revisions. You'll see that the original request from the Finance Department was to increase the amount that needed to have formal sealed bidding from $20,000 to $50,000. There are two additional amendments that were made to this. The first that you see as you go down was, I think, in part to address a concern that Mr. Pendrell raised at that first meeting about the transparency of the informal bids. So this would require that for a period of 2 years, the purchasing division maintain a copy of all informal bids. And then I did put an exception in there. There are sometimes portions of bids that may include proprietary information. I wanted to make it clear that if there was proprietary information, that would not be provided. So the idea here is if there's going to be informal bidding and it doesn't go through the public, going to the city council for approval, at least there would be a mechanism for members of the public to be able to look at those bids and to review them. And then the second provision, I think, came from, again, a couple different people who were involved, was we currently have a small and emerging business program. It was to make sure that have a charter amendment that required that we did have a program. It doesn't lay out what that program is, and then to make every good faith effort feasible to utilize small and emerging businesses in all contracts. Obviously, we have to be somewhat careful so that we don't act in contravention of the federal Constitution as well as the Nebraska Constitution. So, and that's one of the things that we have in our small and emerging business program. So this would require that program. Obviously, what the program looks at is legislative, and that would be determined by the council with the ability of the mayor to either approve or veto. So anyway.
We'll open this up for a public hearing.
Good, never mind, go ahead.
Anybody from the public wish to speak on this item? Seeing none, public hearing's closed, and comments from the committee.
Yeah, really quick, on the first part, keeping the informal bids for 2 years, that's transparency. I have no problem with that. The second part, I just want to ask city legal this. So, and I support small business and all that, that's not the issue there. Does this create any legal burden against the city at this time, or does it constrict how we can do bids, or having this provision?
Well, we've had a small and emerging business program for the
Right.
better part of 10 years. And it has not restricted how we could do bids, but of course it has to stay in compliance with those constitutional provisions. And I expect you're really talking more about the use of the word every is probably the word that you're probably most concerned about, I would guess, in the last
Correct.
sentence. And that could certainly be changed to soften it. I don't think we could read the charter in a way that would force us to act in a manner that was inconsistent with the U.S. Constitution or the Nebraska Constitution.
Well, right.
Excuse me, and those restrictions are lowest and best bids.
Well, it's lowest and best bid, but there's also you can't
Interstate
set
commerce.
quotas and goals and,
Yeah.
and those types of things as well. I mean, you can't have an affirmative action program where you're awarding somebody based on their gender, color of their skin, those types of things.
So does this heighten the burden that the city has to oblige to those areas and take those into account more, or is it just kind of a goodwill statement and that then it's handled legislatively by the council?
I would assert it's a goodwill statement requiring that we have such a program. Ultimately, the program has to be established legislatively.
That was my first question, was do we have this program? Secondly, do you think it will always be called this program? Because we're now putting this in our charter. So what if the name of the program changes from the federal government?
Yeah, there's always that potential. It has become a term of art in government. I mean, I think if you go across the country, you're going to see that term of art used. There's no question that could change.
And I'll add, when we set up this small and emerging business program, we struggled with what to call it, as opposed to quotas like Bernard said, or some other name. We came up with this to get away from race-based quotas and try to emphasize a small business. That's the term that we came up with. I suppose it could change at some point, but.
Salgado here. For the record, I'm very familiar with the program. I highly support the second part to this amendment, providing them the opportunity to gain some of the contracts for the city. There is a program, there's a tier 1, there's a tier 2, that follows that SEB program. It does need a little house cleaning, but overall, I think it was meant to help that small businesses. So the big guys don't get every single little contract that the city sends out. There are bigger contracts that are over the amount that we want to raise it to, that the bigger guys can do it, but so the small guys and gals don't have any opportunities. So there is already a list for the city for the small businesses to register and be approved by the city to bid on these contracts. So, the best and lowest, right? So I highly recommend that is definitely put into the charter.
Other comments?
Barker, I gather there's city employees who are really advocating for a lift in the purchase amount to $50,000. I was really persuaded by Mr. Pendrell, who's no longer here, that $50,000 seemed like too high a figure based on his experience of what happens in Lincoln. And without making a motion, I'd like to advocate that we lower that figure, and I would suggest $35,000 is sort of splitting the difference.
Is there a second to that?
I would say for Press, as one of the members of the committee, that was kind of our conversation of that was the give and the take of that we could raise it to the 50,000 to match what is happening at the county level as well as the state level. But then to counterbalance that and to address Mr. Pendrell's concerns that by having these bids available publicly, it was really the best of both worlds, that any bad actors then could be rooted out and be found by looking at their pattern over time. And then for the vast majority of city employees that are doing the right thing, all this is doing is speeding up governments, allowing us to get these bids done in, a week instead of multiple months, that they would just have more freedom to continue executing on their jobs and waste less time on busy work at the end of the day.
I think that the concern you brought up, Andrew, about that, dealing with the amount, I think 50,000 is reasonable. And I understand Mr. Pendrell's concerns, and I think having the documents available to root that out, if there's a pattern practice, sunshine will hit it. But the second part of it is inflation. So when was the $20,000 started?
1956.
Yeah, that would be well over $100,000, I would say. And as someone that works with organizations that have to get quick bids and contracts, you create more bureaucracy. So I'm fine with the 50,000.
Is there a motion on that?
There was. No.
Number 35 was our second? Okay. Okay, hearing no second, the motion fails. Any other discussion on this point?
One question I had for Ms. Plucker was, when we suggested this change, we very much had in mind that the city has an existing program here, and so that's where the very explicit mention of that came in. Would it make you and potentially you, Mr. Kennedy, feel more comfortable if we change that to instead reference broadly a program targeted for small and emerging businesses instead of directly referencing that program by name?
It sounds like this program is well embedded, and Mr. Kratz said they carefully considered the art of what to name it. So I'm comfortable moving forward with how it is. I would make that motion if one is needed to. Do we need the motion to?
Are you making that motion?
Yep.
Motion to do what?
I would make a motion to accept the language in.
As written.
As written in 5.16.
Okay.
Somebody just seconded it.
Yep.
In my row, mind you.
Okay. Any other discussion? Now we'll do a vote. Let's go ahead with the vote.
Barker.
Aye.
Bonet is absent. Fox.
Aye.
Is absent. Kennedy.
Yes.
McPherson.
Yes.
Morgan.
Yes.
Pendrell is absent. Plucker.
Yes.
Christi.
Yes.
Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion approved.
The next one is proposed charter section on 5.17. It looks like we've just approved changing from 20 to 50,000, so.
Yep.
Mr. Innenbosch, do we need this?
This is obviously the second part of that, which changes the requirement to go to the city council to match the amount that you need to have competitive bidding for.
Reddick.
It's a different section. I apologize.
It is.
Public hearing. Seeing none, public hearing's closed. Comments from the committee or a motion from the committee?
Motion.
Reddick here, I motion we approved as written.
Second.
Okay, we'll call vote.
Barker.
Yes.
Bonet is absent. Fox.
Aye.
Carroll is absent. Kennedy.
Yes.
McPherson.
Yes.
Morgan.
Yes.
Pendrell is absent. Plucker.
Yes.
Christi.
Yes.
Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion approved.
Next item is section 5.20.
This
Mr.
is
Innenbosch.
section 5.20 is another request by the finance department. Currently, if the city has real property that it no longer needs and it disposes of it, it goes through the process that's outlined in here. The money from the proceeds of that particular sale by charter goes to the Advanced Acquisition Fund, and that would remain that for most purchases, with the exception that's being requested here is that when there's a sale or exchange of property that was originally purchased with funds from an enterprise fund, then that money would be returned to the enterprise fund. The city has a couple of enterprise funds that run independently. The main one, and the one most of us talk about, is probably the parking fund. That fund collects revenue from parking meters and parking garages and uses that money to replace meters, pay for employees, maintain the parking garages, ultimately build new parking garages that are financed by bonds that are paid from the revenue. So the theory, at least with the enterprise funds, is that they run independently and that any They're not subsidized or cross-subsidized by the city's general fund. So, as I said, this was a request here. Obviously, some of the motivation for this request was I think the city recently sold a parking garage because of the current language in the charter that the proceeds of that sale went into the advance acquisition fund for the city as a whole, as opposed to going back to the parking enterprise fund.
Public hearing on this item? Any public comment? If not, the public hearing's closed. Comments from the committee? Actually, I'll jump in. I oppose this from the standpoint, I think this ties the mayor's hands with respect to funds for various purchases, and we ought not to do that. Secondly, it tends to create, I mentioned this before, I think kind of a little bit of a fiefdom where money is put into one particular area and cannot be reached except for certain purposes. I know Mr. Pendro mentioned, and I was surprised that the state has about 800 of these type of funds, which is, I guess, discouraging from my standpoint. In any event, that's my comment. So, any other comments?
McPherson, you said you oppose it, so what would be your recommendation instead?
I would not adopt this suggestion. I would not modify it or change it at all. Let me put it this way. I would not change this particular section.
I concur with you, Paul, on that issue on that, and that's the problem is you create these funds. But the other side of it too is kind of what our role is. I'm not the financier of the city. I'm not the mayor. I'm not the council. The council has the inherent authority. If they had a problem with the way that the charter is doing this, they could make those proposals anytime outside of our time, or they can do it when they vote on our proposals. So I just think this is something better left alone. I'm going to vote no.
I agree with you, Mr. Kratz, as well.
So I'm sorry.
Presta, my question here would be, and sorry for retreading water from when we had this discussion before, but since these are separate enterprise funds, if said enterprise fund, just to not throw department names out there, bought a building and then they disposed of that building so that they could purchase a new building, they would have to pull for that new building that they'd be purchasing, not from the proceeds of that previous building, but from their funds that they're making revenue from, correct?
If this language is adopted, that's the way I understand it, is that they would use money from this particular fund and could be used just for them, as opposed to the mayor suggesting we need money for another building or another land purchase. She would not be able to do that.
Yeah, I think to answer your question, historically, if the money was an advanced acquisition fund, if the mayor wanted to use the fund to buy a parking garage, she's been able to do so. Mm-hmm. If the money is now in that parking enterprise fund, it would be limited. I think that's the point that Mr. Kratz was attempting to make.
And so I guess my question is that once the enterprise fund is set up, they are self-sufficient to a point, but the city could still acquire property or other things on behalf of said enterprise fund. It's not that they're, cut off from their parents, so to speak, and they're off in the real world on their own.
Well,
I might add, some of those funds are not self-sufficient. The golf fund, for example, is not, and there are probably a couple others. So,
I mean, I think theoretically they're supposed to be self-sufficient, but the reality is that
and I just know in certain governments or entities, they are treated fully as self-sufficient, so.
I'm sorry.
No, that's fine. Sotolongo, my question would be, purchase of any land or existing property to redevelop as a parking structure that will be city-owned, is that going to come out of an enterprise fund that is related to parking revenue?
Well, I think that's what the planning department is hoping to accomplish in part by making this recommendation is the proceeds from sales would come in and then future purchases would come from there. That doesn't mean that that always would be the case.
The reason I bring this up is that we have a streetcar project that's going to be obviously occurring over the next few years, and strategic parking is going to be a concern, and so the city will be active, I'm certain, in acquiring property to create strategic parking along that line, and I want to make sure, I guess, that that's not hindered in any way and that the funds are readily available. Do we see those threatened in any way? That would be my question.
I guess from my standpoint, the way I see it is that if we keep it the way it is now, that the city as a whole can provide the funds for the parking. Otherwise, there's an argument that it'll be limited to the enterprise fund. So I think you have more flexibility if we do not adopt this change.
So basically, McPherson, keeping it in the advanced acquisition fund, right? And everything is underlined. We just reject the, right? Well, no, we're not gonna table it. We would reject it.
Yes.
Right? Motion to
Motion to
deny,
deny.
thank you. I don't have my little notebook. I should have had that.
Is
Thank
there a
you.
second? Let's do a vote.
Yeah. Yes.
Kennedy.
And a vote yes is to deny.
Correct.
Barker,
Yes.
Donut is absent. Fox,
Yes.
Kennedy, McPherson,
Yes.
Morgan,
Yes.
Pendrell. He's absent, sorry. Plucker,
Yes.
Christi,
Yes.
Quinn,
Yes.
Reddick,
Yes.
Salgado,
Yes.
Sotolongo,
Yes.
Kratz.
Yes.
Motion approved.
Okay, the next one is section 5.21, disposal of personal property. Mr. Indenbosch.
All right, this was another amendment proposed by the Finance Department, and I'd call it probably a cleanup amendment. The city entered into an interlocal agreement with Douglas County, I believe it was in 2008, for Douglas County to perform its purchasing functions. So there is a purchasing division that serves the city, but it is not a purchasing division that's under the authority of the finance director. It's under the authority of Douglas County, and we provide some of the funding for it. So the purpose of this, we've had this provision in our charter for a long time. Whenever there's personal property, i.e. personal property that departments feel is no longer useful, we see it, for example, with bulletproof vests that may have expired. Police department wants to dispose of those things. There's a process outlined in here that says you have to go through this process in order for it to be disposed. There is also an ability to potentially donate it, and that's laid out in here as well. But basically, this is to remove references to the purchasing division and the purchasing agent, who, though there is a purchasing division and a purchasing agent, they're no longer city employees or a division that's under the city. Instead, it's now, the request is to make it the finance department and the finance director.
Public hearing. Seeing no comments from the public, we'll close the public hearing. Comments from the committee? Or is there a motion from the committee?
Second.
Roll call.
Barker,
Aye.
Fox. Oh, he's absent, okay. Health is absent. Kennedy. McPherson,
Yes.
Morgan,
Yes.
Charles absent. Plucker,
Yes.
Christi,
Yes.
Quinn,
Yes.
Reddick,
Yes.
Salgado,
Yes.
Sotolongo,
Yes.
Kratz.
Yes.
Motion approved.
All right.
Okay, Mr. Indenbosch, the next section is
The next item is
5.23.
section 5.23, and I will acknowledge that there is a typo in the first sentence. It says the city treasurer shall, obviously the word be is missing, be. This again is another cleanup provision, and I'll attribute, Ms. Quinn let me know about the typo, and I told her we'd make sure it got corrected. This was requested by the finance department. At what point in time, the statute provided that the Douglas County Treasurer provided the treasury functions for the city. That's been changed through changes in state statute and previous amendments to the city charter. But this particular language contemplates that the finance director would appoint a city treasurer. The city treasurer is in fact a classified position that's selected through a merit and fitness examination. And this is intended just to make that explicit. So we would ask that you approve it as amended by adding B to it.
Public hearing. Does the public wish to make any comments? Seeing none, public hearing is closed. Comments from the committee? Or a motion from the committee?
Motion to approve section 5.23 as written.
How about
Second.
as amended?
As amended,
As
I'm sorry.
amended.
Thank you.
Second.
Let's do roll call vote.
Barker,
Yes.
Fox,
Yes.
absent. Kennedy, McPherson,
Yes.
Morgan.
Yes.
Charles absent. Plucker. Christi.
Aye.
Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion approved.
Next section, 5.26.
So the next section is 5.26. This was a recommendation that came from the Finance Committee, and I think the original request came from Charter Convention member Koth, who suggested this. The purpose of this is to require that the city prepare and make available to people who ask, as well as on their website, something that indicates all bonds that are outstanding, when they were, the principal under the bonds, the rate on the bonds, the term of the bonds, the balance owed, and ultimately the total anticipated cost. That way a member of the public would always be able to review the bonds that the city's issued and be able to find all those particular functions. Would be required to be shown on the city's electronic media, but would also be available to citizens upon request. This is another one of the I think, transparency requests that we see from a variety of people.
Public hearing on this item. Any comments from the public? Seeing none, the public hearing's closed. I will comment, over my life, over my career with the city, been involved in many issues, bond issues, and they are available to the public. It's a little bit difficult to find them sometimes. This will probably clear it up from that standpoint.
Yeah.
I'll provide a better mechanism. Pardon? Yeah, I think so, yes. Any comments? Okay, is there a motion?
Barker moves section 5.26 as amended.
Second. McPherson.
Okay.
Vote?
Barker.
Yes.
Fox.
Yes.
Kennedy. McPherson.
Yes.
Morgan.
Yes.
Plucker.
Yes.
Christi.
Yes.
Quinn.
Yes.
Reddick.
Yes.
Salgado.
Yes.
Sotolongo.
Yes.
Kratz.
Yes.
Motion approved.
Section 7.03, Bernard.
Yep, and this is another proposal that came out of the Finance Committee, which also had the responsibility of reviewing Chapter 7 of the Municipal Code. So this particular amendment has two basic provisions, but you're going to see from this amendment and the next amendment that it's really an attempt to incorporate consideration of affordable housing as well as sustainable development in the code. So the first section that it makes is we do have a city planning board. That city planning board is made up of 7 members, 6 from the city, a 7th who lives outside the city's corporate limits. This would impose a requirement that one member of the planning board be somebody who works full-time for a nonprofit corporation that is involved in providing affordable housing. The second amendment that you see down on the section of item 3, that section deals with responsibilities of the planning board to review particular ordinances and amendments, and it imposes a requirement on the planning board to consider how those ordinances, whether they be land subdivision or zoning ordinances, address affordable housing and the sustainability of residential development. And obviously, if the committee member wants to add more, happy to turn it over to them.
Public hearing? Seeing nobody from the public, we'll close public hearing. Comments from the committee?
I'd like to hear some information from some people who are on the committee.
Mike, I was on the committee. This is Quinn. There was a lot of conversation coming to us from the public on affordable housing in general and many facets. And as we looked at it, I'm not an expert, but how is the best way to incorporate affordable housing into the charter in some fashion? I think, there were a couple different places on here. What place is the best place to put it? Is it in the planning department? Is it in the city council? Where is it where we can get the, at least acknowledgement that it is an important part of the city? And I think sustainability too, when you have the city charter and it's 10 years old, things change in 10 years. And sustainability should be mentioned somewhere in there. Now this amendment, as Bernard said, the following amendment also talks about the sustainability issue. So that was the best spot the finance committee could determine. We're open.
And I would say from other conversation on the committee that this is something that is by no means rare. Looking at other boards around the city, like the land bank, there's a requirement that we basically took this from verbatim as a requirement for one of their 7 members. And then looking at other planning boards or commissions in other cities, whether it's Denver, Houston, Minneapolis, St. Louis. I mean, just spot checking, I didn't find one that didn't have some type of special carve-outs, whether ex officio or appointments by certain members or including schools or parks or other members that had interests that were not that were not in the development field directly.
I think that's a good point, Andrew, because here's the kind of thing. I think affordable housing is a big issue for the community. The second part is like you brought up there, is that an ex officio position where there's somebody that gives information and guidance to the planning board from the community to talk about those issues, or that's actually a physical vote? And that's the only thing I have a hard time getting my head around, because there may be other people, because there may be someone from sustainability. Where we're a sustainability group, we want a seat on the planning board. And I worry about that type of creep, but I think you're right and Angie's right. There is a thing in our community that we want to have those type of issues addressed. I just don't know if this is the best way to deal with it. That's my only take on this, is because housing is a problem. And yeah, we do want to be socially responsible and recycle and do these things, but I think the other part of it is, how do you make that balance? And I'd rather have somebody make those recommendations to them, or have a requirement they look at that, as opposed to just picking, because who's the group gonna be?
So that would still be appointed by the mayor as written. They just would have to work full-time for one of those entities as kind of that test of, where there might, where their experience and where some of their motivations may lie. And so just to clarify, are you mostly talking about the first part of this amendment around that member, and you're overall fine with the second amendment later on in 3?
The second one, it's not big of an issue just to raise that, so we discuss that. But that first one, I think does the mayor's office have a position on that part? And I know there's 2 people here from the mayor's office here.
And I was going to ask Mr. Kuzi, I see him standing up there. Has anyone talked to the planning department?
I did, Matt Kuzi Law Department. I spoke to Mr. Fanslaw, who's the head of the planning department. His only concern, he was fine with the second amendment, and it wasn't an objection to the first part, but the concern was, and to some extent the mayor's office can concur with this, when you put a level of specificity onto a membership position, it can shrink the pool down to make it very difficult at times to fill the position. And we don't want to have a planning board that's not fully comprised of the membership that it should have. As you can see, the current language is very vague. People who live in Omaha and one person who's inside of our zoning jurisdiction. So that was the only concern that he relayed to me, that I said I would relay to you, that when you do put that kind of specialty in there, the example I get from the mayor's office sometimes is, one of our many boards and commissioners requires like a landscape gardener to be on it, and that's a very specific job, and a very specific job that also requires a certain amount of time commitment that a landscape gardener may not be able to do. So it presents a level of difficulty to find someone to do that. So I promised planning that I would relay that concern to the convention, and there was no issue about the second amendment. He just wanted to make sure everyone was aware.
Was there a recommendation?
As to the first one?
To just, yes.
They didn't state a recommendation. Probably one can be inferred from the planning department's comment. And Mr. Innenbosch, I'm sure, would say this, because I heard some questions about affordable housing. It is addressed by the planning department, and there's specific section, division, part of the planning department that specifically deals with affordable housing on a very regular basis. So it's not being overlooked within the planning department as a whole, but in terms of an actual representation on the planning board, there could very well be one now. It's just this would create this kind of specificity which could hinder ability to find people to be on it.
Mr. Kuzi, as you said that, I was reminded, I sat on the initial land bank board, and there actually was an issue because of the specificity of some of the membership. I think it was banking and finance of all. You'd think there'd be a plethora of availability from folks that wanted to serve, but there wasn't. And so there was a number of meetings that we went, still searching for someone because of that specificity requirement in the statute. So that reminded me of that.
So DeLongo, as a current member of the planning board, I mean, I would reject the First Amendment based on the fact that it all but guarantees a position on the board for a very small subset of organizations in town, and I just feel that I feel it doesn't actually increase the breadth of expertise on the board. I think it reduces it. I think right now we actually have quite a diverse board in terms of our professional careers and experience, and I just see this as an opportunity for one of those seats to not be able to go to someone else that could bring a really unique perspective. And I will tell you now, affordable housing is something we speak about every single month. It's constantly brought up. We get an opportunity to see the public testimony every month, and we hear the concerns, and it's just a consistent theme. And you won't find one member on that board that won't sign on to approve something to increase the level of awareness and dedication to affordable housing right now in the planning department or the board itself. So that's what I would say.
Do you want to make a motion?
I do have a question for Bernard. Clearly, we see that affordable housing is a very major issue in our community, especially in communities like North Omaha, where 60% of residents are renters and not homeowners. I do have a big concern for the people that live there and the displacement that often happens with new developments. So from a legal perspective, what is the feasibility of like a rent control cap on new developments requiring a certain percentage or number of units to cap their rent to provide an affordable rate for low and median income residents?
Well, I'm not going to give you a glib answer because I don't know. I've never looked at the issue. Obviously, that's something that's done. Something like that's been done legislatively in places, but I want to look at that. I'd want to research that issue before I opined as to the legality of it. I'll be frank with you.
I did a little bit of research. I don't see any statutes that forbid or endorse any kind of rent cap or rent control in the state of Nebraska. But like I said, you're the expert here, so I'm just asking to pick your brain.
No, and that's a fair question, and I think depending on whether it's possible or not, then the next question to ask is whether that's something that's really a charter consideration, or is that a legislative item that ought to be addressed. And I know there's been some talk about, in addition to the recommendations for charter amendments, that this body might end up making some recommendation for some legislative things to be considered, and that might, but I'll try to take a look at that, and then maybe we can have the discussion next month, or next meeting, or I'll talk to you offline.
Sounds good. Is there a motion?
Yeah, do we have a motion?
I'd motion to amend the proposed amendment to section 703, striking the first portion, and then also in the second part, striking residential from development. That just, it seems like sustainability and affordable housing should be considered for development of any sort if it's going to be considered, especially at least sustainability.
So we would remove the word residential from item 3. Okay.
Is there a second?
Second.
Let's do a vote.
Barker?
Can we have comment on this now that we have a motion before us?
If you'd like to, sure.
So I'm going to vote against this. I think this is a terribly important issue for the city. I trust our corporate community, but at the end of the day, their profits will drive decisions, and there's not a lot of money to be made in affordable housing. And I don't buy that this seat won't be filled. I think this is a desirable board to be on as opposed to the land bank. And this is broad language, involved in providing affordable housing. That's all kinds of religious institutions. It's all kinds of large charitable institutions in town. It's not just Habitat for Humanity. There are plenty of people, I think, who do this, so.
Is the issue, Rediker, is the issue around the specificity of someone involved in, or excuse me, a nonprofit corporation that is involved in providing affordable housing versus a nonprofit in the community that is affected by affordable housing? For instance, all of the places that Mr. Barker just mentioned.
The way I read this is broad enough that any charity that's involved in helping to provide affordable housing.
But so my question with for the whole charter is that issue is the reason why we're striking it down because of the specificity of being involved in affordable housing versus if we were to say to strike being involved in affordable housing and more so a nonprofit in the community itself, which could be anybody on there. Hope Center's not involved in affordable housing, but we could sit on that board if necessary. I'm not volunteering, I was just saying.
My objection to it was not the fact that it was related to affordable housing at all. It was just the designation of a voting position on the board to a specific, either nonprofit or a specific type of nonprofit. I mean, I think where does that end? As Mike said, we could be then requiring a different use and a different position, and then I just think that the planning board has been operating pretty well and actually already satisfies this. You've got Sydney Franklin on the board right now, and she has been an incredible advocate for North Omaha and redevelopment and affordable housing, and she's not the only one that's behind all of these efforts either. So I would just say that, I guess I would just add that.
Quinn here. Just one more comment. You know, sitting on the finance committee and trying to take all these considerations in and where do they go? I thought some great points were made this evening regarding 7.03, and you know, I do agree with, I think Mr. Kennedy said it, Mr. Sotolongo said it. You have 6 or 7 members, and boy, it's affordable housing now. In 10 years, it's going to be, or you know, sustainability or clean energy or whatever, and pretty soon all your seats are taken. I guess that's my point. I agree that we need to keep it in there on the second spot, item number 3 of that. I think that seems broad enough with the amendment that Mr. Christie made, striking residential, and I'd be fine with striking the first part with them becoming a member.
Okay, we have a pending motion. That motion is to delete the first suggested amendment to 7.03.
I think Mr. Fox had a comment.
Fox, I just have a comment.
Sorry.
I agree with Mr. Barker. I think that affordable housing is such a conversation in Omaha, and I think it's important to intentionally have someone that sits on the planning board that focuses on this and comes from that place in our community. It's not just, I don't think we're going to have a problem finding anyone to address affordable housing or come from that sector. It's a topic that comes up in every city council meeting that I attend, almost every meeting that I'm at. And I think that making intentional steps to put someone on a group who comes from that area is important. I do respect everything, the other opinions here. I think that affordable housing, especially as we enter into one of the top 40 cities in the country, like you explained, we need to make steps like the other cities that you mentioned that have the same appointed person from that sector, like St. Louis and Denver and other places. I think that we should be the same.
I just want to add as well, if you guys want to see more affordable housing, we need to have legislative solutions that everybody can advocate for those in the community right now. We have very few tools to actually produce affordable housing quickly, efficiently, and sufficiently for the needs that we have in our city. So you know, just because we put this in here, it's not going to solve our affordable housing issue. We need to actually build more units, and we need to be able to streamline that process, and that starts with legislative changes. I just want to say that as an aside.
Other comments? Okay, we have a pending motion. The way I understand it is that the first suggested change in 7.03 would be deleted, and then the second suggested change in subparagraph 3, the reference to residential would be deleted. So we're voting on the motion at this time. I guess we'll take a roll call vote on that.
Barker,
No.
Fox,
No.
Kennedy,
Yes.
McPherson,
Yes.
Morgan,
Yes.
Plucker,
Yes.
Christi,
Yes.
Quinn,
Yes.
Reddick,
Yes.
Salgado,
Abstain.
Sotolongo,
Yes.
Kratz.
Yes.
Motion approved.
Then as amended?
We have a motion.
What?
As amended?
I guess, yeah, we'll need a motion as amended.
Motion as amended.
A second.
Who was the second? Oh, okay.
Sotolongo.
Okay. Roll
Okay.
call.
Barker,
Yes.
Fox,
Yes.
Kennedy,
Yes.
McPherson,
Yes.
Morgan,
Yes.
Plucker,
Yes.
Christi,
Yes.
Quinn,
Yes.
Reddick,
Yes.
Salgado, Sotolongo,
Yes.
Kratz.
Yes.
Motion approved.
Paul, real quick, just one
Yes,
thing
sir.
here. I know we were talking about giving the council maybe ideas that come up that maybe do not pass, but ideas on that. I think there was enough discussion on the affordable housing that we can make a recommendation to council that that was important to the committee, and then to look at ways to expand that, or to have presence on that, or to give input to the planning board. Even though we didn't pass it, there was an agreement that there should be some type of input given on those areas. I mean, just for the record.
I think it's a good idea. Maybe it's something that when Bernard puts everything together, you can add that at the tail end of
I made a
items.
note about a half hour ago to send out an email to all of you this week to ask you for any suggestions to the council, not necessarily recommendations, but suggestions that we wanted to include, so I could put those on the discussion for conversation.
Okay.
And maybe at the next meeting.
Next one, 7.04, reference master plan.
All right, this is another amendment proposed by the Finance Committee, and frankly, in many ways addresses some of the discussion that we've already had. The master plan, I know people talk about it as one document, but the master plan, in fact, has numerous elements. And as you go through the list at the bottom, we do have an urban services element, a transportation element, a parks and recreation element. The purpose of this is to add 2 additional elements to the master plan, one being affordable housing development and one being sustainable development, which would require the city of Omaha to have those additional elements, have a report, just like we do for all these other areas. I mean, obviously, there's probably some overlap, but there's overlap with some of the existing elements as well, so.
Public hearing on section 7.04. Seeing none, public hearing's closed. Comments from the committee or a motion?
Did Mr. Fanislaw comment on that?
Matt Kuzi, Law Department. Mr. Fanslaw was sent everything that involved the planning department, and the previous item is the only one he gave a comment on. He has no other comments in any of the other items that appear before you today that would affect the planning department.
Thank you.
A motion?
I'd motion to approve the amended version of section 7.04.
I'll second it.
Comments? Okay, roll call.
Barker,
Yes.
Fox,
Yes.
Kennedy,
Yes.
McPherson,
Yes.
Morgan,
Yes.
Plucker,
Yes.
Christi,
Yes.
Quinn,
Yes.
Reddick,
Yes.
Salgado,
Yes.
Sotolongo,
Yes.
Kratz.
Yes.
Motion approved.
Okay, the last item for today is section 7.05.
Can't believe we
Regarding
made it
the master
here.
plan.
This is another amendment requested by the Finance Committee. there was, I think one of the citizens raised an issue about how frequently the master plan and elements of the master plan are reviewed. This is kind of an attempt to kind of look at the middle. Ms. Quinn asked me a question, I think, over the weekend once about the various elements of the master plan. I found those elements on the planning department website, but it was very inconsistent as to when the last time there was city council action on those elements. Some of the elements, 3 or 4 of the elements, had been evaluated in the last 3 or 4 years. And some of the elements appeared that they may not have been formally reviewed since Hal Dowd was mayor, more than 22, 23, 24 years ago. So the purpose of this is not necessarily to require the city to engage people to do an additional, redo the element every 10 years, but require that each element of the master plan, and those are defined in 7.04, the section we just looked at, be reviewed by the planning board and the city council at least every 10 years. So just ensuring that those are reviewed. And then if there were no changes to be made, and frankly, I think there was an expectation that might be the case frequently, that the city council would adopt a resolution recertifying that element. The thought process here, I think, is that every 10 years, we would know that each element of the master plan was at least looked at, reviewed, and a determination made as to whether it needed to be updated or revisited.
Public hearing? Come on down.
Nope.
State your name and your address, please.
Am I required to state my address, or? Okay, cool. Just curious. Marcus Chafee, M-A-R-C-U-S, last name Chafee, C-H-A-F-F as in Frank, E-E. 1304 South 6th Street, Omaha, Nebraska. So I'm long-time listener, first-time caller. I appreciate all the deliberation that's going on, talking about such important issues. There are a lot of things going on in our community, and I think it's really great that we have this opportunity every 10 years to really contemplate the directions that we want to head as a community, and having it be so representative of the different parts of our city. I only think it's fair that we do something similar with our, what I would call a comprehensive plan. I don't really like the term master plan. So I would just consider that, where were you 10 years ago, 20 years ago? When I looked at the master plan, when I first moved here about 2 years ago, I saw references to now that we're at the turn of the century, or 1991 when the first meetings were made. As a person who works in the planning field, it was just, I don't want to say anything negative, but it just kind of took me back to be like, where am I moving? How far back in time am I moving, even when I think about the planning principles that are coming up? So I don't think it's too wild of a proposal that we could set into standard that as a community we will come together and we will convene an instrument that is not just, you know, a visionary tool that's not really used. It's something that can be inspiring. We can use this time to convene members across the community about these important concepts in order to develop a blueprint and a plan for how we're going to address these emerging issues, whether that's, you know, now sustainability and affordable housing, but to whatever things might be coming up in the next 10, 20 years. And I think it's important that we put that into a document that represents our city and that we carefully review that. So I support this option to make it a requirement that we as a city take this planning seriously, so that we don't find ourselves in predicaments that cause us to sprawl looking for ways that we can incorporate affordable housing into the various parts of our function. It's something that we as a community have had an opportunity to define for ourselves, and to deliberate largely. As a personal, you know, I find public engagement to be a super important part of all of this. And I hope that by instilling this plan for every 10 years that we can really start to develop a civic engagement that shows that we are all part of Omaha and we all have a part to play in helping to shape that future. And so with that said, I appreciate all your time.
Thank you.
Thank you. Any other public comments? Public hearing is closed. Comments from the committee or a motion from the committee?
Sotolongo, I want to lend some support to this. I think it's a good idea, and to echo what the gentleman said, I mean, I think this is really important as a growing city. And I would even support a convention-style review of this once every 10 years with a group of people that, from the community, from all sectors and all levels of expertise to sort of set the stage for where Omaha's going in the next 10 years. And so I just want to offer my support and say that I'm going to approve this.
McPherson, I would echo the same, everything that was stated. Thank you for your comments. 10 years is even a long time. When you think about affordable housing's impact in terms of even drawing prospective residents to our city and state, they look at many factors, and affordable housing is an important one that they look at. So at a minimum, 10 years. I think when you think about the flow of technology and urban renewal and people making now moves even faster than before in terms of their jobs and occupations, 10 years would be the longest period I would look at. But right now, it's not happening at all. So it needs to happen.
Well, and I might help point out that the elements, I think the shortest element is 40 pages long, and the longest element's about 200 pages long. So these are not relative. These are relatively complex documents, which I think maybe helps somebody understand why 10 years might make more sense than a shorter period of time. I wanted to add that because as I think Ms. Quinn and I looked at the website and looked at the length of it, and all the various elements together that we have are over 800 pages combined. So,
McPherson, again, I had a chance to talk to a couple of folks in this august group here, and so I would say, per this conversation, I would move that we approve, which one is this?
7.05.
Thank you, 7.05 as written.
It's not been amended, it's as written, right?
We're ready to vote.
Okay, any other comments? If not, let's
I do have one
Oh.
comment, because there was some conversation, interest in more public participation. So as written, there's only a public hearing involved. So just an open question before we vote, if that's something that would like to be
There's actually two
incorporated.
public hearings, because there'll be a public
Or two,
hearing
yeah.
before the planning board and a public hearing before the city council.
Correct. Thank you, Bernard.
And our subcommittee in our first meeting discussed a few issues such as accessibility, issues with looking up the master plan, how readily available is the master plan, and I think we've got some recommendations coming that Bernard will be working on later on.
Bernard's going to be busy.
Yes. So I guess my question is, before voting, would we like to incorporate more public feedback in a manner similar to this, or do we want to leave the process as it currently is? I just wanted to ask the question before we vote on this, and then have to backtrack if there is significant interest.
I think that one is I support this, the 10 years. I think organizations do that. The library has it. Public schools do and all that. But I think 10 years for what you're doing on development, I think that's the right time. 5 years would be too short. But
Can you mic it?
oh, I'm sorry. The problem I see though is you already have public input through those meetings. I think that when it happens every 10 years, I think it's incumbent upon those organizations to put out there what they're doing and look for and solicit input. I don't think that's a function of the charter. I think that's the function of the council and the planning board doing that. So, yeah.
And I will mention that this master plan is not something just put together willy-nilly. It's a very involved process that takes a lot of time. I'm talking many months' time to put together. And like Bernard mentioned, there are 2 public hearings at least.
Yeah.
So we have a motion and a second. Roll call.
Barker,
Aye.
Fox,
Yes.
Kennedy,
Yes.
McPherson,
Aye.
Morgan,
Yes.
Plucker, Prestai,
Aye.
Quinn,
Yes.
Reddick,
Aye.
Salgado,
Yes.
Sotolongo,
Aye, aye.
Kratz,
Yes.
Motion approved.
Okay, next meeting is July 11th. We'll have a couple items that are laid over from this agenda, and Bernard will have some more for the next one.
I have five items that were suggested by city staff that haven't come before you. I'll do that, and then if the committees have any additional stuff, obviously, reach out to me.
McPherson, so I really enjoyed this group. I enjoy the dialogue. I enjoy learning from you. I enjoy even listening to some of the Discord. Is this our last meeting coming up on the 11th?
We can have more if we need.
No, I didn't ask for more.
So right now it's scheduled as the last meeting that's scheduled. I do have an alternate date scheduled for July 14th in case we need it, which I know is the same week. But the reason I did the same week is because obviously we're getting close to that time that the city council has to act in order to get stuff on the ballot.
Correct, which is why I'm talking. So I believe that there should be a concerted effort from everybody who's on the subcommittee to communicate whatever they've been talking about to you so that it is our final meeting. Otherwise, we have stragglers who come up. And so I don't know if there's any plan to follow up with subcommittees to make sure that, is there anything you have, because that last minute stuff doesn't work.
Agreed. Any other business? If not, we're adjourned. Thank you.
Yep.